Nervosity is increasing.
Hello, and welcome to the JGLS Insolvency Public Lecture Series. We're very excited to host you for the first Insolvency Lecture Series. And our first speaker for today is Dr. Christoph Paulus, and we also have the Executive Dean and Professor Dr. Shijit with us, who will be giving us the inaugural address for this public lecture series. We hope you enjoy the session and stay with us till the end. And without further ado, over to you, Professor Shijit.
Thank you. Welcome, everyone. Good evening from India and Jindal Global Law School, OP Jindal Global University. I have great pleasure, while feeling honored indeed, to invite you all to the first edition of the Jindal Global Law School Insolvency Distinguished Public Lecture Series. Insolvency and bankruptcy, although are corporate maladies, are larger repositioning and reorganization from how things stand. For that very reason, for that very loss of equilibrium, they are not free of disagreements and disputes. However, governments of late have been trying to simplify the insolvency proceedings and the creation of a framework of payment arrangements to minimize its impact on economy and the market at large. The JGLS Insolvency Distinguished Public Lecture Series aims to address this topic of extreme relevance. The 4 lectures this week and the subsequent ones that would become part of this set are focused on international and cross-border interactions with multi-jurisdictional disputes, restructurings, and the local insolvency laws. These lectures are designed to give us insights into the insolvency frameworks in both civil and common law jurisdictions, including India. Our first lecturer of this distinguished lecture series is Professor Dr. Christoph G. Paulus. Professor Paulus is had an illustrious service as Professor of Law at the Humboldt University, Berlin from 1994 to 2019. There he held the chair for civil law, civil procedure, insolvency law, and ancient Roman law. He had studied law at the University of Munich and has done his LLM at the University of California, Berkeley. An expert primarily in insolvency law, Professor Paulus has been regularly consulted by IMF and the World Bank. From 2006 through 2011, he served as an advisor of the German delegation on the UNCITRAL insolvency law sessions. He has lectured worldwide and has held guest professorships at various universities. He is a member of various international institutions, such as the American College of Bankruptcy and the International Insolvency Institute, of which he has been a vice president until summer 2017. Since his retirement in spring 2019, he is associate member of South Square London, and since 1st of September 2019, of counsel with White & Case Berlin. In today's lecture entitled Insolvency Law, the Beginning and the European Insolvency Regulation, Professor Paulus will focus on the development of international insolvency law and the EIR recast, looking at the private international law aspects which the EU has adopted in the treatment of cross-border claims amongst its various member states. JGLS is honored to host Professor Paulus for this lecture series and extend him a warm welcome. I also take this opportunity to acknowledge the remarkable initiative and leadership shown by my colleague, Professor Ishana Tripathi, Assistant Professor, Jindal Global Law School, whose commitment to insolvency law is incomparable. On behalf of Jindal Global Law School, I extend a warm welcome to all those who are connected to us through YouTube. Welcome, Professor Paulus. The floor is yours.
Thank you so very much. I feel almost ashamed, and in any case, I feel very much honored by such an extremely nice introduction. And let me say that I really, really deeply appreciate the invitation to speak at your university. I've never lectured in India, and I have always seen this as a big lacuna in my life span so far. And insofar, I'm more than happy to be here with you. And Thank you also to you, Ishana. You started the contact and it was just fantastic. So since I have a lot to talk about, as a matter of fact, I could talk for a couple of weeks on the topic, which I'm supposed to cover now in 45 minutes. Please allow me to immediately switch over and to share my screen and to show you where we are. I hope I have it. Oh my God. This would be a disaster. It should be now here. No. Yeah, here we go. So we have International Insolvency Law, the beginning, and the EUR. I mean, I was introduced as having had the chair also in ancient Roman law. And for that reason, please forgive me and bear with me that I'm starting with saying a few words about it, really old history. After all, it's really interesting to see that in antiquity, so we are talking about something like 2,500 years ago, in Mesopotamia, we had an concept of a debt relief after 5 years, taking now as a starting point that you had throughout probably mankind from the very first beginning. You had the situation in which someone who had promised something in the end of the day could not fulfill what he has promised. And then we have a sort of the beginning of an insolvency in a situation. And how do you deal with it? In Mesopotamia and in the Old Testament, you find there was a debt relief after 5 or 7 years, and then it was over, and then the things started anew. In Rome, however, which was extremely influential in developing the subsequent 2,500 years up to today, you had, instead of being sort of humane with the debtor, you had the killing of the debtor or the enslavement. And once the debtor was killed, then the distribution of assets, and when he was kept alive, then he was the debtor was kept alive, but he was inflicted with shame cultural penalties, something like social death. So it's a kind of, we are not talking, we have no contact with this person, which is really disastrous. I mean, we all get right now a feeling in the lockdown situation, what it means to be excluded from the society. And there was also, for centuries, the punishment of a debtor was a return to the physical death. So it was a killing. That was really, really widespread. Now, this is sort of beginning. And today, and therefore I find this slide particularly interesting, we are now moving back, even in that part of the world, which is more or less the entire world, which is influenced by ancient Roman law. We are coming back, we are moving back to Mesopotamia. We are now looking for a discharge after 3 years, after 5 years, or what have you. So it is all of a sudden back to the Old Testament in Mesopotamia, and forgetting about the Roman sources from which we come. Now, since I'm supposed to talk about cross-border insolvency, I should begin by making you aware of what you are already aware of, namely that I'm a European, which means that I speak, and I'm fully aware of that, far too much from a Eurocentric position. As I've written here, I know little to nothing about India, Brazil, Korea, or the rest of the world. Incidentally, I heard from a Korean on another panel on which I had been 2 years ago. From a Korean, I heard that there too, it was for centuries before adaptation of the Western law, whatever that is, it was the tradition to kill the debtor once the debtor was not able anymore to satisfy the creditors. Okay, that is the warning, the general issue I wanted to raise with you, that I would be more than happy if you could either tell me afterwards or write me an email or whatsoever, if you have anything to say about how insolvency was treated in ancient societies outside of Europe. Coming back to Europe, in Italian cities in the Middle Ages, there we are talking about 1200, 1300, 1400. There was an enormous trade area. I will come back to trade area 2 slides later. It was more or less northern Italy was a trade area, and they created and they enacted insolvency laws, and they made a lot of copying from each other. I mean, that's the usual way how we lawyers work. If I would ask you, all the people who are listening to what I'm saying or watching me right now, if I would ask you, my dear friends, my dear students, if I would ask you now to, for instance, set up a statute on the property law on the moon, on the Mars, how would you work? How would you proceed? You have now the official order. Please create the new structure, the property structure on the moon. How would you proceed? The answer, or my guess, would be, you would first be confused. You would say, oh my God, how can I do that? I've never been on the moon. I don't know how it works. An hour later, once you have drunk a tea or coffee or whiskey or whatsoever, you will settle down a little bit and you will say, well, let's make it this way. We are looking at other places who have already a property structure. And then you would take, let's say, the property law of India, the property law of Australia, of Brazil, of South Africa, or of England, and you would say, well, let's see if we can adjust this to the needs of the moon. That is the traditional way of how we lawyers, how we invent new things. We are taking old models and adapt them to the modern times needs. You see this right now, incidentally, as an aside, you see this in the internet sphere. Who is owning the data? Who's owning the data of the car you're driving, and the car creates data? Who's owning them? It's a huge question. And here we have, again, the question, who owns it? Apologies. I'm coming back here to Northern Europe. I'm now here. The same happened around 1520 to 1600 in Northern Europe. Again, you have the Netherlands. It started in Antwerp. All of a sudden, there was the town fathers of Antwerp who recognized they need a functioning and effective insolvency law in order to attract investment. This is very modern formulated, but as a matter of fact, if you look at the letters, and I did it, if you look at the letters, in modern terms, it's exactly that. We need the foreign merchants in order to attract them to our place, in order to get rich, to bring investment to our place. That is what insolvency law is all about. I probably will come back to that a little bit later. If not, I'm saying it already here. When I was asked to work as a counsel for the IMF, it was exactly in 1998, it was exactly this question. How do we get investors to the countries in this world? And an essential part is you need to have a stable, effective insolvency law. So we have it in the Netherlands, in Antwerp, it began. And all of a sudden, within 20 years, or less than 20 years, France followed. The King of France, all of a sudden in Lyon, created a French insolvency law. And then within 8 years, England, the King Henry VIII, he followed and set up that what the English authors tend to describe as the first insolvency law in the modern times, which is of course nonsense because it was copied from the Netherlands and from France. But there you can see how what a burning issue that is to have this internationality and this attractivity for foreigners. Now, we had also in the Middle Ages, or in the later centuries, we had treaties and trade alliances. It's called the Hanse. That was an economic area in the Northern Europe, covering also the Scandinavian countries and what is today Russia and Poland and Germany and Netherlands. So it was a huge alliance. And they had also special rules in treaties. And interesting to see, particularly in the times of today. And with today, I mean today, 2021, 2020 and 2021. Because they had special rules with insolvency if the debtor went bankrupt without fault. And that was, for instance, the examples given were emergencies such as fire, flood, or war. And here comes what I add here, the pandemics. I mean, that is exactly the situation in which we are. And one of the questions is, does it really work, our insolvency rules, in a situation which is something like our pandemics, in which nobody can be blamed for this incident? Now, I switched to modern times. Please believe me, I skip dozens of examples and dozens of developments, but for the sake of coming to the European Insolvency Regulation, I abbreviate dramatically and tell you, before I come to that, what I find, how shall I put it, sort of a model, a raw model for modern times. Or if it's not modern times, then at least a strong political recommendation that I would like to give. When you look at the last, let's say, 150 years, you see all of a sudden that in Latin America, that was in 1800, around 1870, they started, 6 countries in Latin America, they started to build a region and to enter into a treaty. And the treaty was dealing with how do we deal with cross-border insolvencies. Cross-border insolvency meaning the insolvency of a company, of a person, which is living in Ecuador and which is doing business in Peru. So how are we dealing with this situation? And that was covered by these treaties. Funnily enough, and strangely enough, Latin America came up with at least 4 or 5, I don't remember correctly, various treaties dealing with insolvency. None of them worked. It's strange insofar as America, with the exception of Brazil, they are speaking the same language. I will say a few words about language on the next slide when I come to the European Insolvency Regulation. We in Europe, we are speaking 17 different languages. And please believe me, there is no way for me to understand, for instance, someone from Finland when he's speaking Finnish. No way. There is no communication possible. In Latin America, if you are in South Patagonia, in the south of Argentina, and you come up to the north to Mexico, you still talk the same language. You speak Spanish. They can communicate. Nevertheless, it doesn't work. It's hard to understand. Nevertheless, the Scandinavian countries, the next region which entered into an insolvency treaty, it works fantastic. It works smoothly. They include Iceland. They include, of course, the Finland, Norway, Sweden, and Denmark. And it works fantastic. Then we have the NAFTA project. Now after Trump, it's now USMCA. That NAFTA is the North American Free Trade Area. And that is an area which is combines, interesting for lawyers, extremely interesting, 3 jurisdictions: Mexico, the United States, and Canada. Why is it so interesting? Because Mexico is a codified system. They have their law from Spain. The United States, as you all know, is a common law jurisdiction. And Canada, funnily enough, is a mixed jurisdiction. The province of Quebec is a codified system. The rest is common law system. And they have come together, a couple of people under the ALI, American Law Institute, and they have sat together for a couple of months, more than a year, and they came about with the rules on cross-border insolvency law. It works fantastic. It's a fantastic project. And then you have another region, OHADA. That is an African region. It combines, it puts together, and it's heading, there are 16 or 17 Central African countries. They have a couple of rules. It's what is it? It's a business law anyway. And one of the codes they have is on insolvency law. Incidentally, they have just adopted, they changed the previous model to now the modern application of the UNCITRAL model law. So there you have another region. And then we have the EU, and I will talk afterwards about the EU. But if you look at this slide, if you see three regions, the Latin American countries, they were always changing a little bit. It was not always identical, the participants, there were several. So you have Latin America in 4 versions or 5. You have the Scandinavian countries, you have the North American countries, you have the Central African countries, you have the European Union. Now I'm wondering, and I made the proposal a couple of times. The last time I think that was in Southeast Europe, the Balkanese countries. They have the same tradition. They have been neighbors for endless times. If they wouldn't want to consider to set up their own region and their own cross-border insolvency law. And elsewhere I think that was in Singapore, I made a similar proposal to that region, including, let's say, Malaysia and Indonesia and what have you. Because central is, and that brings me to the next slide, brings me now to Europe. And before I talk about Europe, I want to include something which is essential for the functioning of cross-border insolvency law. What you need is trust. Trust is quintessential. You need to have the trust into the jurisdiction, and in particular into the insolvency law of the other country with which you are working together, or of which you are supposed to recognize an insolvency proceeding. Trust is essential. I give you an example of where the dangers are. Insolvency law can be used, and that is one of the big challenges of each legislator in any jurisdiction. Insolvency law can be used as a disguise of an expropriation. I assume that the students who are listening now to me are too young to remember a case which took place a couple of decades ago. No, it was something like 25 years or so. There was a Russian case, and there was one of those incredibly rich people who had an incredibly huge empire as an enterprise. And this guy, Chodorowski, he was an entrepreneur, of course, extremely successful, extremely rich, extremely influential. He all of a sudden, he changed interest and he wanted to become a politician. And that's a dangerous thing. And for that reason, the insolvency proceeding under very dubious circumstances was opened. And this guy, Chodorowski, was put into jail, well, in a gulag for something like 10 years, and now he's living in Switzerland. And that was a proceeding which had waves in the United States, in Poland, in the Netherlands, and elsewhere. And it was always the question, is it possible to recognize such an insolvency proceeding? Because in the end of the day, it was well, that's how I interpreted it. And I wasn't not by far not the only one. It very much looked like an expropriation. Expropriation of Khodorkovsky, who had become too rich, too powerful, and too influential. So if you know this, then you get a feeling of what is meant by trust. And trust as being the essential for cross-border insolvency law, and in particular for recognition within insolvency law. So for that reason, this approach of the previous slide, and allow me to go back for a moment, once again, pointing out that we have regional approaches. Regions are insofar interesting or particularly apt to create something like these treaties, because they are neighbors for centuries, for millennia. They know each other, and they share usually a couple of commonalities. And that can be made use of, and that is something which creates a sort of basic understanding. And if this basic understanding develops a little bit more, you have all of a sudden something like a first step of trust. And then why not starting a treaty like that and working together in terms of cross-border insolvency law. Okay, now I'm coming back here to my slide. We had in Europe, we have a common history, needless to point out, for literally forever. And nevertheless, during the last 1500 years, before the end of World War II, we had something like 1500 years of war. We waged wars against each other every 10 years or so. It was incredibly. And nevertheless, after the end of the World War II, a couple of politicians sat together and said, well, let's try to come over this situation, which is disastrous and leads to nothing. And let's try another way. And they did so by treaties. So it's a legal instrument. The treaty, a contract, as you want, as it were, a contract by which you try to overcome historical powers or incidents. Now, why did nevertheless many attempts fail? It was, number one, lack of trust. And number two, that is, whenever I say that, I have a bad conscience, because I feel that I should apologize to those who are listening, because it reminds me always of a kindergarten. It has been one of the biggest hurdles, has always been tax claims. Cross-border cooperation was always unsurmountable when it came to tax claim. If the neighboring country, was lodging its tax claims in my country's insolvency proceeding, then the argument was, and that is really kindergarten, I feel set back into the kids playing with their toys and saying, no, this is mine. So the argument there was always, my insolvency proceeding is not there and is not determined to collect your taxes. What the hell? That is silly in my understanding. Nonetheless, that was a strong counter-argument. And then we overcame this with the European insolvency regulation. Before I come to the insolvency regulation, I should mention something which I'm pretty sure that you have heard already about, but nevertheless, I should mention it in order to get a plain level feel. We have on the one side the territoriality principle, on the other side the universality principle. What does it mean? I come, in order to make this as crystal clear as possible, I come with a silly example. I'm quite sure that many of those who are now listening to my presentation, that they know that in Germany, on the Autobahn, which is the freeway, or however you call it, the Autobahn, there you can, if you have a Porsche, or if you have any other car which is driving like hell, if the street is free and empty, you can drive 200 kilometers, you can drive 250 kilometers per hour, as ever you want. There is no, at least generally speaking, no restriction to speed, which is, I can tell you, at least sometimes it's fun. It's fun to drive 250 kilometers per hour. You are allowed to do that if the circumstances permit on the Autobahn. Now, I, being a German, and having driven more than once 250 kilometers per hour on the Autobahn, what do you think happens when I drive down, let's say, to Austria and further on to Italy? There I'm on the Autobahn, and let's assume there is nobody on the street, no other car, no nothing, it's free. And I, being a German, I say, well, I'm driving now 250 kilometers per hour. And all of a sudden I'm stopped by the police. The police are saying, well, my dear friend, you are now here in Austria, you're not allowed to drive faster than 130 kilometers per hour. And then my response would be, well, maybe that this is true for the Austrians, but I'm a German. I'm allowed to drive 250 and faster. Is that a valid argument? Answer, no, of course not. And that brings me back to territoriality, because it is up to the legislator of Germany, of Austria, of Italy, of India to decide what is permitted and what is forbidden on the territory of this particular country. What reaches beyond is beyond the powers of the legislator. Now, if that is true, and you see the example of driving 250 kilometers on the Autobahn, and I'm sure that you have fully understood the implications of that. If you apply this rule, however, on an insolvency proceeding, what happens then? Imagine you will see no change, no difference, no implications, no nothing. If we are talking about the insolvency of, let's say, an Indian shopkeeper who has a shop in, let's say, in Mumbai and one in Delhi. So, and this guy goes bankrupt, well, then you couldn't care less about whether there is a territoriality issue or a universality issue, because there's no universal thing, there's no cross-border implication. But if you have a company which has, let's say, its seat in Delhi and has a factory in Indonesia or in England or wheresoever, then all of a sudden you have these implications. You have something which goes cross-border. And then comes the big question. The insolvency proceeding in India is opened. And India, let's assume for the moment, is following the example of this this speed limitation on the Autobahn. It's following the territoriality principle and saying the Indian insolvency law is applicable only within the borders of India. If that would be applied in the case of our insolvency case, which I just mentioned with this cross-border implication, then the shop or the business in Delhi would be subject to the Indian insolvency law, and not affected at all would be the factory which is in Indonesia. Which consequence would that have? It would be primarily probably the banks, but also other creditors who are well informed, who receive in the Indian insolvency proceeding, let's assume 5% satisfaction on their claim because of the equal treatment principle. They receive just the dividend. They would immediately think, well, I've lost now 95%. Where do I get it from? They would, because they would be informed about the factory in Indonesia, they would go to Indonesia and would look for an enforcement of a money judgment. And then they would get satisfied, let's say, probably by the rest of the 95%. That means the well-informed creditors would be satisfied in total, but wouldn't receive, but the other creditors, which are not as well informed, would suffer from the pari passu principle, the equal treatment. There you see that the insolvency territoriality comes with problems. It's legal dogmatics at its best, but also at its worst. Because the confinement to the territory is counterbalancing the economic effects. And for that reason, we have nowadays worldwide, more or less, there are still exceptions, but more or less, we are all following the universality principle, which in the end of the day, because of this sovereignty concept, the sovereignty concept meaning that the Indian legislator is allowed, it is perfectly free, but also confined to decide on what happens within the territory of India. So if we are saying now we are following the universality principle, then in the end of the day, it's nothing than asking the rest of the world, please, people in Indonesia, people in England, wheresoever, would you be good enough to recognize the Indian claim to have universal effect? So it's nothing but an invitation to please be good enough to accept and to recognize our domestic claim. So that's what cross-border law, insolvency law, is all about. And therefore, a recognition is quintessential. Now I'm turning to the insolvency regulation, the European insolvency regulation. In the end, after all these many attempts, which I mentioned just before, there was a couple of people. It's always, that is the usual way. You have a small group of people sitting together and they are drafting at least the first draft. And then you can work with this. And there we had a group of something like 10 people sitting together, and they came up with the first draft. And that turned finally into the insolvency regulation. And there you have, and that was a couple of years later, it was a little bit more elaborated. But here we have, again, the universality principle versus territoriality principle. And that is what more or less towards the end of our class I'm now presenting to you. The idea is, and I hope that you did understand my exemplification of why it is necessary in insolvency law to pursue the universality principle. And the insolvency regulation pursues this goal. It wants to be universal. And that you can see by 3 articles, which I have addressed here. Let me begin with Article 3, paragraph 1. It says there should be just one insolvency proceeding. In theory, and in the best of all cases, it should be just one insolvency proceeding. At this point, short interruption. something like 30 years ago, we had a very, very famous case, the Maxwell case, in which was a huge group spreading all over the world. And there we had the disastrous experience of that there were two openings of a main proceeding. One was in New York, the other one was in London. And that would have meant, in the end of the day, if you have one insolvency dealt in two proceedings, which are parallel to each other, or which are claiming each other to be the only one, the right, the correct, the only insolvency proceeding, you have two competing insolvency administrators who are spending millions and millions and millions of dollars or pounds for lawyers which are fighting against each other. In the end of the day, they fight until no money is left, and the creditors will have received nothing, and a couple of lawyers will have become incredibly rich. So there was this disastrous example that we had, and we want to avoid that. And in order to avoid it, we have this determination of where is the main proceeding. The main proceeding is where the debtor's center of main interest is located. Now, once you have this one opening spot, let's now assume, for the sake of example, it would be Germany, it would be Berlin, where I'm right now here. Then we have Article 7. Article 7 says that this proceeding would be governed by German insolvency law. Of course, I mean, that is quite clear. But in combination with Article 19, this means something sort of revolutionary when compared with the millennia before. Article 19 is saying that all other member states of the European Union, and we are now, after the Brexit, we are 27. So once the insolvency proceeding is opened here in Berlin, all other 26 member states, from Ireland down to Greece, from Portugal up to Estonia or Finland, they will automatically recognize the German proceeding. Remember, trust. We are saying we are trusting each other. So this German insolvency proceeding from here in Berlin will spread, as it were, over the entire region of the European Union member states. And it will be governed, and this is revolutionary, it will be governed by German insolvency law. This is Article 7. However, that is the universality approach. Nevertheless, we are not yet in an ideal world, and therefore we have in the insolvency regulation, we have concessions to the needs of present day. And there we have included a couple of instruments which can be described as remnants of the territoriality principle. Number one is Article 3, paragraph 2. This article allows, once the insolvency proceeding here in Berlin has been opened, it allows, let's assume for the sake of example, to open a proceeding, an insolvency proceeding in France or Italy, which is, however, confined, which is confined to the borders of France. So there's a territorial proceeding within France running under French insolvency law. Now, under which circumstances is it allowed to open such a territorial proceeding in one of the member states? There you have the definition of you need an establishment. Establishment is a kind of compromise, and it's a combination of personal means and physical means. I'm not going into that. Under certain sort of aggravated circumstances, you are allowed to open a territorial proceeding. Then you have the main proceeding under the German law, main proceeding in all of the member states, if you look at the map of Europe, you have all is covered by this insolvency proceeding, but in a different color, you have a special insolvency proceeding. It's still the same debtor, but it's a second insolvency proceeding, a secondary proceeding in France, running under French insolvency law. So this is exception number one, concession to territoriality number one. If there is an establishment, you can commence a territorial proceeding. Then we have the Articles 8 and the subsequent ones. There you have certain exceptions of this Article 7. Article 7, I remind you, is the article which deals with German, or which says that German insolvency law is applicable all over the member states. Certain exceptions apply. And I named just one, and that is labor law. If you have the German debtor here in Berlin running, among others, a factory in Lithuania or in the Czech Republic, and there are workers, or they are employed under Czech law, then it would be in the consequence of Article 7 to say, well, in the insolvency case, then German insolvency law is to be applied, or German labor law is to be applied, at least as far as it is related to insolvency situation. Article 13 makes an exception to that, and is saying, nope, in the case of workers, the domestic labor law is to be applied. So there you have an exception. The last exception, which is a sort of emergency brake, as it were, is the public order exception. You can deny the automatic recognition of Article 19 when and if under very, very, very limited circumstances, when there is a violation of that decision on the public order in your country. So, Ishana, I think time is over, is it? And under these circumstances, I would thank you very much for your attention. And I hope I made it sufficiently clear what I wanted to say. And once again, if you have anything to say, feel free to write me emails or whatsoever. Now, Ishana, I hand over back to you.
Thank you so much for that interesting history till now transition, Christoph, because one thing that I want to fixate on and probably take forward as a discussant for this lecture is the word trust and enforcement that you very interestingly raised. Now, there is a bit of a tussle between the UNCITRAL cross-border law and the protocol under it and the EIR, because a lot of European jurisdictions have resisted in adopting the UNCITRAL model law, whereas the recent case where you're looking at the Netherlands and India adopting a cross-border protocol within the UNCITRAL framework, and India is aggressively pushing the UNCITRAL model law, adoption of the UNCITRAL model law on cross-border insolvency. Speak to us a little bit about what this tussle is and how do these two laws respond to the question of trust? Because funnily, every time I talk about Europe or the EU in my classroom, there is an assumption that it's one country. It's not, because it is the EU law under which we're having the conversation about cross-border. So give us a little bit of an insight about the legal tussle between the two.
Thank you. That's an extremely interesting question. Well, let me begin with the following. I have to talk about sentiments. Apologies, but that is sentiments. It is a widespread, it has been, and to a certain degree still is a widespread argument that this working group 5 at UNCITRAL, where you have, it's a fascinating experience. And I had the privilege, as I in the introduction was you have heard, I had the privilege of having been there. There you have usually something like 60, 70 representatives of various jurisdictions sitting together, discussing twice a year for each 1 week on a particular text. So you are really fighting for words. And the understanding, of course, the negotiations usually are, or the dominant negotiation language is English. And I'm afraid I have to say that this is an obstacle. It brings me back to the language issue. Many people were saying, not only in Germany, also in France, in Spain, and Italy, well, this is a forum which is primarily dominated by the common law countries. And it's true. I mean, when you look at the English guys and at the US guys, they are very present. They have a big saying. They are sending their best people, whereas the German ministry, for instance, usually have sent civil servants who had to do the job, but which were not really experts in the field. So there you had a clash of same level of intelligence and of expectation and of intent. The civil servant doing the job, the judge from the Southern District of New York trying to convince the world that their law is the best. So that is a sort of stigma which is on the uncertain model law in the continental world, that it's too heavily inflicted on or influenced by common law. That's number one. Number two is brings me back to trust. The model law, by definition, coming from the United Nations, and not from the European Union, is not a region. It's the global enterprise. So you had to take into account the specificities of, let's say, Japan, as well as Uruguay, as well as Canada, as well as Switzerland. So you have to take into account completely different historical backgrounds, evolutions, and that ends up in just, there is much less trust into each other than in a region like Europe, the European Union, or the regions. That is what I find so extremely fascinating with this regional approach. And I'm really surprised that no more people are jumping on this, because they could sit together. And if you look at it, you have on that slide 5 regions mentioned. And each of these regions has developed ideas, which is something like the fight, a struggle for the best solution. I mean, that is like a market situation. You try to develop the best product, and only 5 participants are on that market, which is hard to understand. Does this answer a bit of your question? I should finally mention that in my last article, which is to appear, I think, next week or so, I made the proposal to the European Commission that they should enter into a contract or a treaty with the United Kingdom in which they are establishing the UNCITRAL model law. Let's see what happens.
Right, that's a very interesting take on common law versus civil law in terms of jurisdiction conflicts, because the assumption that a civil law system will work the same everywhere is sort of misplaced, because the common law factoring that you mentioned kind of allows for a symmetry between how common law jurisdictions react to certain corporate commercial or insolvency sort of cases. So yes, I do take your point on the aspect of territoriality and how it could be a bit of a tussle in terms of language, in terms of enforcement, and in terms of trust. Now, the second question, though, as a consequence of what you've said, is the fact that the business aspect of the UK and the EU, now separate, is requires a sort of rethink of cross-border and enforcement, right? And what do you think will be the resistance or the acceptance of entering into a cross-border arrangement or adopting a unilateral model law on cross-border insolvency by the EU and the UK? Or do you think that it would be a separate treaty which sort of imposes provisions of the EIR in that contract between two countries? What do you think? How will that kind of play out? And I ask this primarily because the consideration is whether you adopt the international law as is, or you enter into country-specific arrangements in terms based on businesses and the business interaction that you have with different jurisdictions for India.
Yeah, extremely interesting question. And once again, I mean, we could and we would have to discuss it seriously for hours. Nevertheless, a quick response is the following. The UK is more than happy, or would be more than happy to enter into such a treaty with the European continent, with the European Union, because then things are working better. Right now, it is a foreign country. But once you are a member of the model law group, and after all, right now there are 51 jurisdictions who have adopted that. Then you are at least closer. You're not as close. There's no automatic recognition. It still takes an order of the judge controlling, but it is, you have cooperation, you have coordination, you have, it's a first step towards creating trust. And that is a fascinating thing with the model law of, or all model laws of UNCITRAL or UNITRA or wherever they come from. It's a trust creating measure. And now, I mean, unfortunately, and I must say, being an old man, I'm suffering from this most recent development that we are, as it seems, going back more again towards nationalization. I grew up and I lived the major part of my life in a surrounding where we had increasing universality, so to speak. So we had the denationalization. And now we discover with this, I mean, it's one of the symptoms of the extremely influential symptoms has been this Mr. Trump, that America first. I mean, what a disastrous concept in terms of the experience that you made before. So given this, I wonder if the importance, or what happens with the importance of the cross-border insolvency law. I see to a certain degree in Germany, but also in Europe in general, it's less of interest than it used to be 10 years ago. There, everyone was full of enthusiasm. And now if you look through the journals, it's less and less articles which are written about these issues. So maybe it's one of the consequences of the present pandemic that we all of a sudden, well, we recognize all of a sudden that is a danger for insolvency law, that these supply chains, the transnational supply chains are a danger. So if you have a factory which you are dependent on in sub-Saharan Africa, and one in Australia, and one in Guatemala, and you have a pandemic, you have a real problem. And for that reason, there is here in Europe, at least some politicians say we must make our economy less dependent on these global supply chains. There you see problem number one. On the other hand, you see in the pandemic, you're dependent on the producers of the vaccine in Russia, in China, in the US, in Germany, or wherever. And it's an open concept. I, as a person, as Christoph Paulus, I'm of course advocating like hell for globalization. We are just one village, and we have to take care together of this village we are living in. Otherwise, we are killing ourselves.
Thank you for that, Christoph. That gives us a lot to kind of think about in general, because the idea of globalization, as you rightly put it, is possibly the need of the hour in the context of, particularly in the context of insolvencies and how countries talk to each other. So that, as a parting shot and a parting thought, is quite a fantastic way to wrap this session. I am very grateful to our viewers, and I'm mindful of time. I do understand that a lot of you might have questions with this riveting discussion that has just taken place and this lecture. Please feel free to write to me or write to Christoph directly. We're all great responders of emails in real time, so do not worry, none of your questions will go unanswered. As a thank you, a big, big thank you, I want to thank Professor Dr. Srijit, who kicked off this lecture series. It has been a great dream of mine to actually be able to put this together, because insolvency law is not all about practice. We have a big theory practice divide, and that gap needs to be bridged, and which is the purpose of the series. And I couldn't have thought of a better person to kickstart this series other than Professor Dr. Christoph Paulus. So thank you very much for your time, Christoph. Thank you very much, Srijit. And I hope that the start of the series, the gusto of the series, is maintained over the next few lectures.